from Ex-Matters Legal. My name is Esther, and last week we delved into a thorough definition and discourse of the concept of the seat of arbitration, distinguishing it from the venue of hearing. We however noted that the law of the seat of arbitration normally regulates and governs the arbitral proceedings in each respective case. Today we're continuing in our discourse of commercial arbitration, which is a series that we're talking on in these episodes. Today we'll be discussing a very interesting aspect of commercial arbitration, which is the role of national courts in the arbitral process. What are the roles of the courts during arbitration, before arbitration, and after arbitration? We're going to be looking at this concept and this discourse in general terms across jurisdictions, and we're also going to be focusing majorly in Nigeria as a jurisdictional case study. Even though we've mentioned that arbitration is an alternative dispute resolution mechanism which parties opt for if they don't want to litigate their matters in courts, and arbitration, especially when it comes to commercial disputes, is very good option to use because litigating in courts takes a lot of time and it could cripple down business if they need a short time to settle their disputes amicably. Regardless of the definition of arbitration as an alternative dispute mechanism to going to courts, to litigating in courts, we still need the courts, interestingly, even in the arbitral process. Like some of our scholars have told us, Referent Announcer on International Arbitration mentioned and said, and I quote, "It is sometimes said that the relationship between national courts and arbitral tribunal is one of partnership. If so, it is not a partnership of equals. Arbitration may depend upon the agreement of the parties, but it is also a system built on law and which relies upon that law to make it effective nationally and internationally. National courts exist without arbitration, but arbitration courts could not exist without the courts. Arbitration could not exist without the courts. Pardon me. National courts exist without arbitration, but arbitration could not exist without the courts." This is a very interesting notion, and this is what we're going to be discussing in this session today. Professor Liu, Queen's Counsel, mentioned and said, "National court involvement in international arbitration is a fact of life, as prevalent as the weather, which implies that you need the courts, even in an arbitration process." So, how do we need the courts? In what instances do we need the courts? When do we need the courts, even during an arbitration process? These and more are the things we're going to be discussing in this session today. Please ride on with me. The seat theory suggests, as we mentioned last week, that the jurisdictional place of arbitration is not necessarily where you hear the arbitration process, but is the law that governs the arbitral process, which we call, in law parlance as the lex arbitri, or the law of arbitration. So the law of the seat of arbitration will definitely, yes, govern the arbitral process. This makes it very interesting then that we have to also ensure that the national courts of the seat of arbitration favors an arbitral process. So the choice of seat has a significant role in determining the nature and extent of court intervention in international arbitrations. Due to varying national attitudes towards international arbitration, different courts on different legal systems have different ways in which they view arbitration in their jurisdiction. So when parties are defining arbitration costs in their clause in their commercial agreement, and they are signing the arbitration agreement, in case there's a dispute, they need to note that when they are choosing the place of arbitration, when they are choosing the seat of arbitration, they need to consider properly, because when they have to approach the courts in such places, in the seat of arbitration, it must be able to favor the arbitral process. It must be a legal system that actually enables them and allows them to be able to move the arbitration process forward. We mentioned about the Arbitral Model Law 2006 last week, and when we look at the Article 5 and 6 of the Arbitral Model Law, this relates to the principle of non-judicial intervention, but it gives a reasonable framework for instances when national courts can intervene in the arbitral process. So we see that even international conventions, international rules, national conventions on arbitration all agree to the fact that there are instances when the courts are required in the arbitration process. So in general terms, the national courts give shape and meaning to arbitration in the absence of an effective arbitration framework in jurisdictions considered hostile to arbitration by way of pro-arbitration judicial pronouncements. So there are instances where matters are brought even before a court, and the court decides that parties should go into arbitration instead of litigating. And that's a very interesting one, because you would have thought that judges are really interested in litigating. But because they know that arbitration is not going to waste the time of the parties, they will rather opt for the parties to go to arbitration in certain matters, especially, as we said, in commercial disputes. Where the court intervention can be construed as support or mere interference would depend on numerous factors, such as timing, the manner and degree of such intervention. So, what times do courts need to intervene in the arbitral process? What is the degree of the intervention of the courts in the arbitral process? Because we have to also be very careful here that the courts are not intervening in a way that it becomes a litigation. Because arbitration is supposed to be a neutral process between the parties, and the arbitral awards are going to be binding. So the essential role of national courts in supporting the arbitral process can be categorized into three distinct interfaces: before the arbitration, during the arbitration, and post-arbitration. So we're going to take it one by one. Now we're discussing in general terms across different jurisdictions. Before arbitration, the intervention of the courts may be necessary before commencement of arbitration. In what instances? 1, to enforce the arbitration agreement. Normally, in standard commercial contracts, as we have mentioned in our first session when we're discussing introduction to arbitration, in a standard commercial contract, there should be a dispute resolution clause, which is the arbitration clause, which gives the parties the option to go into arbitration in case a dispute ensues based on the business relation. So, when there's an arbitration clause, parties definitely have an arbitration agreement where they sign that, yes, we will go into arbitration. This is the way and manner in which this matter is going to be arbitrated upon. If there's a dispute, how many arbitrators they're going to choose, who are the arbitrators going to be, the seat of arbitration, and so many other things like that would have been decided in the arbitration agreement. So the national courts have a duty before arbitration to enforce the arbitration agreement between the parties. They must adopt a constructive approach by referring the parties to arbitration, giving effect to the arbitration agreement. Because we've seen instances in practice, where parties definitely, they do agree in writing and say, yes, if there's a dispute, we're going to go into arbitration. Then tomorrow, one of the parties wakes up and says, no, it's going to go to court. Then either of the parties to that commercial contract should be able to rise up and approach the national courts of that jurisdiction to say, we have an arbitration agreement, we need the courts to enforce it. So in this case, the court has a duty to enforce parties' arbitration agreement for them to go into arbitration. Secondly, on the establishment of the tribunal before the arbitration process, the court also has a duty to intervene, to appoint an arbitrator where parties have failed to agree to appoint an arbitrator. Normally and ideally, parties should be able to appoint the arbitrators. They should have said all that in the arbitration agreement, how many arbitrators they're going to need, who are the arbitrators going to be in case there's a dispute. However, there are times parties, naturally in human relation, in business relationship, they may not be able to agree. Then the court has a duty the national court has a duty, when approached by either of the party, to intervene to appoint an arbitrator. So the national court assumes great significance in the absence of adequate provisions for the constitution of an arbitral tribunal, and such circumstances mandates the intervention of national courts in establishing the tribunal. So in that case, when the court is approached, definitely, then the court has a duty to ensure that the arbitral tribunal is properly composed if the parties have failed to agree to choose an arbitrator. Thirdly, before the arbitration, when do we need the court? We need the court if there's a challenge to jurisdiction. Jurisdiction in law really is the heart and soul of any matter. There are a lot of times, even in litigation, suits, matters have been thrown out of courts on technical grounds because there's no jurisdiction. And parties can come with a preliminary objection saying one of the parties don't have a jurisdiction to institute a particular matter in court. So no matter how well a case is constructed and conducted, if there's no jurisdiction, then whatever award is given is null and void. So the court has a duty to intervene if there's a challenge to jurisdiction. So in the absence of any agreed rules, the national court will deal with any challenge to the constitution of the arbitral tribunal based on impartiality and independence. So we could have a situation where an arbitral tribunal is constituted, the arbitrator, the chief arbitrator, and the arbitrators have been chosen, and one of the parties decides and says, challenging the jurisdiction of the arbitral tribunal, and says, this arbitral tribunal is not properly constituted, they don't have a jurisdiction, to sit on the matter. Then, that party can approach the court to intervene. So we mentioned like 3 instances here, where before the arbitration, courts can intervene. Also during arbitration, when can courts generally intervene? Certain situations does truly necessitate the tribunal or the national courts to issue certain orders, interim measures, interim orders, interim injunctions during the arbitral proceedings, such as to prevent a party from destroying evidence or request for documents under the control of third parties. Let's take, for instance, the cause of this dispute is probably some goods at the ports and is under the custody maybe of customs, for instance. And that has become an issue between the parties, and it's a very important evidence that should not be destroyed. The court has a duty on the application of one of the parties to the arbitration to ensure that that evidence is not destroyed, whether by the customs in the case that we're using as an example at the ports, to make sure that that evidence is properly guarded because it's germane and important and crucial to the arbitral proceeding. Also, if there's a document that is in control of a third party, then the court can be approached to issue orders for a third party to release that document if it is very important for the arbitral proceedings to be successful. Also, there could be a situation where the arbitral tribunal has not yet been constituted and the court's coercive powers are needed in order to ensure compliance. So during arbitration, yes, parties have chosen the arbitrators, they've said the people that they needed, but yet, if the arbitral tribunal has not yet been constituted within the time frame that it should have been constituted, then the court can issue an order to ensure that the parties comply for the constitution of the arbitral tribunal. So during the arbitration, generally, we see these instances where the courts have to intervene. Also, after arbitration, the court's intervention is very needed. Yes, we have mentioned the arbitral awards, which is like the judgments of the arbitral tribunal. They are final and binding. However, the courts are needed, interestingly, to ensure, that there's compliance to that award. So another prominent support by the courts can be seen after the arbitration award has been rendered. An award devoid of court order lacks the necessary force to impose sanction on the losing party for non-compliance. So when the arbitral award has been given, the court has to be approached to ensure that the losing party complies with that final arbitral award. So the national court orders enforcement of the arbitral tribunal, of the arbitral award. They order the enforcement of the arbitral award issued and given by the arbitral tribunal. And the same is treated as a decree of the court, because there are adverse effects if there is non-compliance by one of the parties to the arbitral awards. However, in limited circumstances too, the national courts in the legal system, especially where the arbitral award is being enforced, the national courts have the power to annul the award, the arbitral award, if there is enough evidence that the process was not conducted impartially, or there's a misconduct by the arbitrators. Then parties can challenge the award and the courts can annul the awards if there are enough evidence to do that. Moving forward, we're going to be talking, like I said earlier, about Nigeria as a jurisdictional case study when it comes to the involvement of the national courts in arbitral process. The Arbitration and Conciliation Act, Chapter 18, Laws of the Federation of Nigeria, 2004, incorporates the 1985 Arbitral Model Law of International Commercial Arbitration. This act is a unified legal framework that governs the fair and efficient settlement of commercial disputes by arbitration and conciliation. And it makes applicable the Convention of on the Recognition and Enforcement of Arbitral Awards, which we mentioned last week as the New York Convention, to any award made in Nigeria or in any contracting state arising out of international commercial arbitration. So we see that the Arbitration and Conciliation Act 2004 is the primary source of arbitration legislation in Nigeria. Yes, Nigeria comprises of 36 states and 1 federal capital territory. And so the ACA, the Arbitration and Conciliation Act, does serve as the primary legislation on arbitration. However, in Lagos State, the 2009 Lagos State Arbitration Law applies to all arbitration within the federal state of Lagos, within the state of Lagos, except where parties expressly agreed otherwise. So we see that yes, there's a national legislation, and yet there's still a state legislation in Lagos State that governs arbitration within Lagos State. Moving forward, using Nigeria as our case study, the power of the courts to intervene during the course of arbitral proceedings is greatly limited by the Arbitration and Conciliation Act 2004, because that act clearly defines the scope of the court's power in this regard. We're going to be talking about different sections, certain sections of the Arbitration and Conciliation Act that actually talks about courts' involvement during the arbitration process. Section 34 of the Act states, and I quote, "A court shall not intervene in any matter governed by this Act, except where so provided in this Act." Under the Arbitration and Conciliation Act, the scope of the court's intervention is set out definitively in a handful of sections, and a review of all the sections reveals a limited number of instances in which the courts may intervene during the course of arbitral proceedings. Like we have mentioned in general terms, before the arbitration, there could be a need for the courts to intervene. Same also in Nigeria. Under Section 4 of the Arbitration and Conciliation Act, it talks about enforcing the arbitration agreement. So where one party insists on his right to have the matter resolved by means of arbitration, the courts in Nigeria has the responsibility, based on Section 4 of the Arbitration and Conciliation Act, to ensure that the parties' agreements are enforced by referring them to arbitration. Also, under Section 5 of the Arbitration and Conciliation Act, the court has the power, during in an arbitral process, to issue stay of court proceedings. So the court has jurisdiction subject to Section 5 of the Arbitration and Conciliation Act, which provides that if any party to an arbitration agreement commences any action with respect to any matter which is the subject of an arbitration agreement, any party to the arbitration agreement may at any time after appearance and before delivering any pleadings in court take any other steps in the proceedings to apply to the court to stay proceedings. So, for instance, we have mentioned earlier that the court has a duty to enforce the arbitration agreement where a party approaches it and says they want to go into arbitration. So if one party has gone to court, instituted a matter in court, and the other party insists that we need to go to arbitration, it's the court's duty and responsibility to issue a stay of proceedings in court until the arbitration is fully completed. So the court may, if it is satisfied that there is no sufficient reason why the matter should not be referred to arbitration, the court will definitely stay proceedings in court and refer parties to arbitration. In other words, we are saying that when the action was commenced and still remains ready and willing, the applicant does everything necessary to the proper conduct of arbitration. So the court will make an order to stay proceedings in court for parties to continue with arbitration or go to arbitration to resolve their dispute. Thirdly, revocation of arbitration agreements. That is another area where the Arbitration and Conciliation Act 2004 in Nigeria, gives the court the power. Section 2 talks about a situation where, unless a contrary intention is expressed therein, an arbitration agreement shall be irrevocable except by agreement of parties or by leave of a court or by a judge. The major catch here is the statement in Section 2 that says an arbitration agreement can be revoked by leave of a court or by a judge. So the court has a duty, if it deems it necessary, for the sake of justice. And of course, the sake of justice is relative based on different evidences before the court. So if the court deems it necessary to revoke an arbitration agreement, based on Section 2 of the Arbitration and Conciliation Act, the court can revoke the arbitration agreement. Also, to appoint an arbitrator. We have said when we're discussing the general terms that if parties could not appoint an arbitrator, then the court has a duty, if an application is made to the court, to make sure that an arbitrator is appointed. This is also provided for in Section 7 of the Arbitration and Conciliation Act, which provides for intervention of courts to appoint an arbitrator where parties fail to agree. Also, what about attendance of witnesses in court? In the arbitral tribunal, before the arbitral tribunal, the court has a duty, when it is applied to ensure attendance of witnesses in the arbitral process. So the court is approached to compel the attendance of a witness before an arbitral tribunal to attend the proceedings. This is defined and also given power by Section 23, subsection 1 of the Arbitration and Conciliation Act, which says the court or the judge may order that a writ of subpoena ad testificandum or a writ of subpoena ducis tecum shall issue to compel the attendance of any witness before any arbitral tribunal, wherever it may be within Nigeria. So if a witness is crucial to the arbitral proceeding, the court can be approached to ensure that an order is issued for that witness, wherever the witness is in the country, to attend before the arbitral tribunal. Also, production of documents. Article 24(2) of the Arbitration Rules 2004 mentions and states that the tribunal may at any time during the arbitral proceedings require the parties to produce documents and exhibits or other evidence within such a period of time as the arbitral tribunal shall determine. The Arbitration and Conciliation Act also has an aspect called the Arbitration Rules, which governs as a base for arbitral proceedings in Nigeria. So Article 24(2) of the arbitration rules gives the arbitral tribunal the power to ensure that parties produce documents and exhibits and other evidences. So when in a situation a party does not want to produce the documents, the court can be approached to give orders for certain important documents that are pertinent to the arbitral proceedings to be produced. Also, as we know, that our judicial system in Nigeria is definitely meant to serve justice. So if an arbitrator conducts himself in an improper manner, the court can be approached to remove an arbitrator for misconduct. Section 30 of the Arbitration and Conciliation Act 2004 gives weight to this and gives the court the opportunity to intervene in the arbitral process to remove an arbitrator for misconduct. So where an arbitrator has misconducted himself, or where the arbitral proceedings or award has been improperly procured, the court may, on application of a party, set aside that award and remove that arbitrator for misconduct. So Section 32 of the Act gives weight to the courts to intervene to remove an arbitrator on grounds of misconduct. Also, the court's role in recognition and enforcement of awards is very, very important. And we said when we were discussing the general terms. Section 31, subsection 1 of the Arbitration and Conciliation Act states that an arbitral award shall be recognized as binding and subject to this Section 32 of this Act, shall upon application in writing to the court be enforced by the court. So upon an application, when an arbitral award has been given by an arbitral tribunal, the winning party, the successful party, will take that arbitral award to a court for the court to issue enforcement of that arbitral award. However, Section 32 of the Arbitration and Conciliation Act in Nigeria gives provision to set aside an award. So as the court can enforce an arbitral award, so also the court can be approached to set aside an arbitral award. So based on Section 32 of the Arbitration and Conciliation Act, any of the parties to an arbitration agreement may request the court to refuse recognition or enforcement of an award and set the award aside. Of course, based on certain cogent evidence. Because if not, every Tom, Dick, and Harry to an arbitration process can come to court and say, oh, they don't agree, set aside the award. No. There has to be concrete evidence before the court, placed before the court, for the arbitral award to be set aside. So we have said that a party to the arbitration agreement must make an application to court before the court can intervene. So courts don't just jump in. Courts mind their business when parties are to go to arbitration. But on application of any of the party to the arbitral process, the courts can intervene. The courts have their own distinct powers also, like we have mentioned, to refer matters to arbitration. So we have mentioned today that the dominant theme in this debate about the evolving role of courts in the arbitral process has been that national courts support arbitration and they give credence to the arbitral process. So the court supports arbitration at the pre-arbitration stage. So the court has to be proactive in assisting the efficacy of the arbitral process by mandatorily referring parties to arbitration where prima facie an arbitration agreement exists. And secondly, courts are bound to intervene effectively and grant interim measures, as we have explained earlier, where parties approach the courts for such interim measures and orders. In fact, an added responsibility is cast upon courts to grant interim measures of protection in jurisdictions where arbitration institutions are yet to incorporate, an arbitral tribunal to mediate and arbitrate on certain cases. So on a concluding note, it will be very important and apposite at this stage to use the words of Professor Liu, Queen's Counsel, which says, despite the autonomous nature of arbitration, it must be recognized that just as no man or woman is an island, so no system of dispute resolution can exist in a vacuum. Yes, arbitration is an alternative to dispute resolution, but it does not exist without the courts, apparently. And we have been able to see this today in the various points we've highlighted earlier. So today we've discussed on the interesting notion of the role of the national courts in the arbitral process. We hope this has been enlightening, and we have opened our eyes today to the interplay between the courts and the arbitration process. We look forward to another interesting episode next week. God bless you, and have a great weekend ahead.